Welcome back to Nicola and Sue. Nicola is our legal superstar. Sue is our financial superhero. And between the two of them, they're going to explore the depths. Nicola, just starting with you, in our last session, you said that directors' duties are codified in the Companies Act in some very, very significant detail. So can you just elaborate a little, please, on what these specific duties are according to the Companies Act?
What I will do is I will run through what those duties are, and then there are a couple of duties, or two duties in particular, that I want to pick up on to sort of explore in more depth, because they are probably the most sort of fundamental duties that apply to most of the companies that we see. The Companies Act lists out a number of duties. If you really want to go and look at section 171 onwards, you'll find them. Really, in broad summary, directors have a duty to act within their powers. And as we mentioned last time, that isn't just within the statutory powers that they have under the Companies Act. Various restrictions on powers can be found within shareholder agreements and articles of association. They have a duty to promote the success of the company for the benefit of the members of the whole, a duty to exercise independent judgment, a duty to exercise reasonable care, skill and diligence, a duty to avoid conflict of interests, a duty not to accept benefits from a third person, and a duty to declare an interest in a current or proposed transaction. We will produce a slide or a summary of what all of those duties are in a really sort of screenshot, one slide way. So don't worry about sort of trying to write them all down. But what I do want to do is focus on two duties in particular. The first is the duty to promote the success of the company for the benefit of the members as a whole. And the second is the duty to exercise reasonable care, skill and diligence. And just have a look about what those duties mean on a practical basis in a sort of day-to-day running of the company. So the first thing to say, which is again a reiteration of what we said last time, is that all duties apply to all decisions that you make as a director of a company. And the duties for non-exec directors are no different from the duties for executive directors. So when we talk about the duty to promote the success of the company for the benefit of the members of the whole, which I'm just going to shorten to promote the success of the company because it's a bit wordy, what does that actually mean? What does success mean? There isn't a huge amount of statutory or case law that enables an interpretation of that. But what there is some government guidelines. And what the government says is that success means an increase in a long-term increase in value for commercial companies. Now, if you're a social enterprise or a social venture, you may have a slightly different view as to what success might be. And for that purpose, in your articles of association, we actually make a clarification with regard to what your director's duties are in an enterprise or a social venture situation. And how a director determines, or how a board determines whether they have fulfilled this duty, has a number of component parts. First of all, in determining what will promote the success of the company and what constitutes success will be for the directors to make in a good faith judgment. The courts have no interest in making business decisions on behalf of companies. But what they will do is look at, sort of how did the directors come to the conclusion that they did, that enabled them to make a decision. In order to do that, and in order to determine whether directors fulfilled their obligation to look at this duty, if it's ever challenged, they will look at what evidence there was that directors considered this duty. And this is where I come back to my very favourite subject of board minutes. If there is no evidence that directors considered this duty, then what the courts will do is they will apply what we call an objective test. It's like a third-party view on what should have happened. An objective test, they will look at whether an intelligent and honest person in the position of the directors could, in the circumstances, have reasonably believed that the transaction or the decision was for the benefit of the company, which is a relatively steep test. If you have documentation of your decision, board minutes by way of example, then what those board minutes should do is detail any relevant factors that the board considered. If there was any particular factor, it's sort of like an overriding factor, perhaps the points that were raised in relation to the discussion of that. And if there was a significant or controversial decision that was made, briefing plans prepared by the management that go with the board packs should detail reference to the duties and how this particular decision or this particular course of action references back to the duties and how directors should be, the factors that directors should consider and how they should get themselves comfortable with following a particular course of action that they might want to follow. What there is also is that with this particular duty, there are a list of factors which are mandatory to consider. And those factors are the likely consequence of the decision in the long term, the interest of the company's employees, the need to foster business relationships with suppliers, customers, and others, the impact of the company's operations on the community and the environment, the desirability of the company of maintaining a high reputation for high standards of business conduct, and the need to act fairly as between members. Not only do you have this test of are you acting in a way that will promote the success of the company, in determining that, you need to consider all of these factors. Now, not all of these factors will be relevant, and you may consider, some factors to be minor considerations in the grand scheme of things, and that is fine. They are subordinate to that overall power, that overall duty. But what you absolutely have to do is consider them. So you need to consider them and eliminate them, or consider them and say, actually, this is an issue and this is how we are going to address this. And one of the things that we are particularly seeing is with regard to the impact of the company's operations on the environment, by way of example, with the increasing commentary around climate change, net zero, etc. We're now seeing that actually being a fairly regular agenda item for boards to, on a regular basis, consider what the impact of their business is. How are they going to achieve net zero? What is their sort of carbon footprint? What are the climate risks actually may impact the way in which they operate businesses? And there is a recommended set of wording that you can put into board minutes to help guide that thought process and that decision. And like I say, it's just coming to the sort of really increasingly coming to the forefront of things. That's my consideration around, promoting the success of the company. And as I say, in relation to anything that looks like a social venture or a social enterprise, you also have the success of the company isn't necessarily commercial success. It's achieving the sort of social impact and the objective which you have set yourself. We then come on to the duty that says that you need to exercise reasonable care, skill, and diligence. So what does that actually mean? This is interpreted as a duty which is exercised by a reasonably diligent person with both, first, the general knowledge, skill, and experience that may reasonably be expected of a person carrying out the functions carried on by a director. And then secondly, the general knowledge, skills that the director actually has. So the first is a general test, an objective test, that sort of general sort of knowledge, skills, reasonableness. The second actually becomes quite personal. Subjective is personal. Subjective means what skills do you actually have? What does this mean, kind of in reality? When it comes to boards and decisions, what impact does that have? As Sue knows, this is where I pick on finance directors quite a lot. Most people around the table are not finance directors, and they don't have accounting qualifications. And therefore, with financial matters, should anything, kind of arise in the future, then you would expect that finance director pretty much to be held to a higher standard of account than other people around the table. Same with people with legal knowledge. The one thing that I would say is that as a director, what you should be doing is if there is anything that you are uncertain of when you are looking at whether, this is an appropriate course of action, then absolutely ask the people around the table with the skill sets, but also don't be afraid to go and get expert reports if you need them in order to satisfy yourself that actually the decision that you are making is the right one for the company. As a director, yes, I'm not saying that you can't rely on the people around the table to have the relevant sort of skill set, and why wouldn't you rely on your finance director or your CTO or whatever it might be in respect of their particular skill set? But albeit that you can rely on it, what you can't do is abrogate your own responsibility. So yes, you are relying on an expert, or yes, you are getting independent advice, but you are still ultimately responsible for the course of action which the company takes, which is why I'm saying actually you shouldn't be afraid to go and get that expert advice, because if anybody questions you as to why did you make that decision, at least you can point to the fact, well, we weren't really sure about it, but so we went and got some advice from a patent attorney, an environmental consultant, or a HR consultant, or whatever it might be, so that you can then say, okay, tick the box. I have done everything I can to protect myself and to ensure that I have made that decision in the right way and in the way that recognises the fact that I have these duties. The other thing that I would just sort of say on that is with regard to the subjective test, so the sort of skills that somebody around the table could be regarded as having by reason of their qualification, by way of example, will also come down to what specific experience they have had in relation to a role they have conducted using that qualification. So if somebody qualified as a lawyer, but actually never did any law, and just went into business and found themselves as the CEO, you can't expect them to necessarily know the ins and outs of law just because once upon a time they did a law degree. We often see again with, things like sort of, again, I'm going back to finance directors, but you see these people sort of parachuted in, oh, it's okay, they've got FTSE 100 experience, aren't they brilliant? We're going to put them into a startup. Well, their experience of startups is going to be very, very different to the experience of being a FTSE 100 finance director. So again, if there was ever an issue, it would be, well, what actual experience do you have in relation to the company that you are currently in and the decision which that company made? So just to conclude on that point, I go back to board minutes again, because if anybody was going to raise a question around whether you considered your duties and what factors you considered in delivering those duties, board minutes are your corporate memory of what you did at what time and why.
Just to reiterate what Nicola said, we will let you have some.
We will summarise this.
Notes to follow on from this. That's a lot of stuff to do. I know you are on not one board, but multiple boards. So how on earth do directors manage the burden of running a company?
Picking up on what Nicola was just talking about and her preference for condemning those in the financial persuasion, I think a very good example of how this can come back in the importance, your skill set and your qualifications and so on to the role that you'll fulfill as a director, is a case that I was involved in many years ago where things had gone very badly wrong for a company. The CEO was in court. The judge turned to him and said, "How did you not spot that this business had XYZ difficulty financially?" The director said, "Well, I'm sorry, I just failed to notice that." To which the judge said, "Yes, but you're a chartered accountant. You have an additional burden of duty as a result of that role." To which said director said, "Yes, but I was very lucky to pass the exams. And I don't think actually, in truth, that's a really good justification or one that anybody should rely upon if they get into difficulties as a director." Joking apart, however, generally, for most companies, you have more than one director to run the business. Certainly in relation to the spin-out companies and R&D companies generally, you won't just be ploughing your own furrow as a sole director. And that's really good because it means that you should be able to have access to a broader range of skills than just those that you yourself bring to the table. I'm going to talk a little bit about boards of directors and what ideally a board should look like and how it should function. It can be very comforting to just put people on the board who are your mates, your spouse, etc., and we see that from time to time. But actually, are those people who would challenge any decisions that you would make? Are they people who would help you to get to the best decisions for the company's benefit? We've talked quite a lot over the last session, and indeed will do today, about protecting your position as a director. But in reality, what we're really looking at is what is best for the company, and coming back to Nicola's point about promoting the success of the business. So to do that, you need to have, firstly, in my view, all the key functions of a business covered in the board that you're running. So if you're pre-revenue, you probably won't need a sales director at the moment. But what you will need will be somebody who is running the technology and the R&D side of the business. You'll need somebody who can understand the finances of the business, and you need somebody who can run the overall operations at an absolute minimum. In addition to that, very often, as we know, investors will look for non-execs to be involved, so representatives of themselves as investors, so they can sit in the room and be assured that the conduct of the company is being carried out appropriately. But if those investor representatives are also non-exec, are also directors, they have a responsibility towards the company and towards its conduct as well, and particularly need to avoid, as we talked about last time, this whole concept of conflict of interest between the interest of their employers, who maybe the investment house, and the duty that they owe to the company to promote its particular success. That's not always an easy road to steer, as we've talked about, and indeed I think Nicola and I have probably seen on one or two occasions. You don't have to necessarily, within the board itself, have those functions. You can access those skills or those attributes from outside the business, but you need to, I think, as a board, make sure that you do have a very formal structure that enables you that sort of access. So if you don't, for example, have somebody in the boardroom itself who is in charge of your R&D, but you sub that out to another institution or other company or something, then you do need to actually make sure that you've got a proper contract with somebody who is supervising that, who has a duty to respond and report into the board meetings. Similarly with finance, you can outsource that. Many companies do, but again, you need somebody responsible so that you are ensuring that you're doing the best thing for the company. It's also, I think, something that is a softer set of principles around selection of the board. It's something that very often people don't pay lots of attention to because they're so busy filling up the functional space that they forget to think about actually the dynamic of how the board actually operates. And it's really useful when you're pulling your board together, certainly your first board, to make sure that you've got the right blend of not just skills, but also behavioural preferences and backgrounds, probably, so that through that diversity you get absolutely the best results for the company. An example of that is a company I went and looked at on behalf of the board to sort of assess why they weren't performing very well and what the key issues were. And we ran a particular psychometric type test which profiled the preferences in terms of behaviours of each of those directors and people involved in key management positions. And what we found was their issue was not delivery, not getting revenue in, things just not being finished, contracts not being finished and so on. And the result of looking at the personality profiles was that everybody around the table was very similar. They were all really enthusiastic to go and win the sale, secure the contract with the customer, but none of them actually had a skill set in terms of focus on detail and a desire to actually finish jobs off. Although one can smile about it, actually, that is really fundamentally important, that you have that full blend of people. You have the winners of work and you have the completers and doers of work. And you have people who will challenge within board meetings. It's not always comfortable, but it is really, really useful. You also need to think about who your external boards are, external advisors, external people that you relate to, who you get information from. You may not have an IP specialism yourself if you're sat within the company, but you will have a patent attorney that you use. And it's really good to build the relationship with your patent attorney, with your lawyer, with your accountants, or all those other specialisms that you need, such that they are themselves a team of support around your, sort of, if you like, the other circle around the outside of your existing executive and non-executive board. You need to be able to just pick up the phone to one of those advisors and just say, we've got a problem, or what do you think about X, Y, Z? And you want to have the sort of relationship where they know exactly where the business is. They will answer you quite promptly, or be able to access the information that you need in order to get decisions made very quickly. So the whole board is functioning as a very dynamic operation. One of the other things that we do see, some companies setting up advisory boards. And Nicola, what do you see in relation to the advisory boards and how those constituted?
Yeah, so advisory boards have a really useful function. Before I talk about advisory boards, I'm just also going to pick up on, what Sue has just said about, having a diversity of thought and diversity of skills around a table. Certainly I can think of one former CEO now, but serial entrepreneur, absolutely brilliant at coming up with a strategy, of identifying opportunities, etc. Ask him to write any of it down. Not a how, other than maybe some bullet points in an email. He sold a company to a large American bank, and he sold it for the best part of £70 million. However, the idea of reading a contract, sort of the actual sales contract, but he did have an absolutely amazing COO. And I will never forget being sat in this large meeting room at one of the sort of Magic Circle law firms in London. And to give some context, this company employed about 35 people worldwide, and the bank had 80 people working on this to onboard them together with their Magic Circle law firm. And after about half an hour, maybe an hour, the CEO, who was the majority shareholder, just said, "Do you know what? I genuinely haven't got them. I'm going to go for lunch." And so he went and met a journalist friend of his for lunch, reappeared about 2 hours later, having had some wine at dinner. And the COO and I had been absolutely fighting tooth and nail over every I and T and everything else in this contract. And he said, "Right, so tell me where we are." And so we're like, "Right, well, we've managed to agree this." "Oh, I'm not worried about that. I managed to agree this." "Oh, that'll never be an issue." We just spent like 2 hours trying to negotiate something for him to come back. But the idea of absolutely brilliant. He's sold 3 companies really successfully, and has actually gone on to fund quite a few Oxford spin-out companies. But yeah, just in terms of diversity of skill set on the board, absolutely have people who can do and can deliver, as well as people who can come up with good ideas. Advisory boards. Advisory boards aren't usually made up of directors of the company, so it's not like a subcommittee of the board. A way of thinking about it is actually they're a bit like a committee that you might put together. They're a group of people that you can go to for often quite specialist advice. So a lot of companies will have a scientific advisory board. They're usually less than 10 people. They're usually really high profile people and quite busy people. It's quite a lot of kudos to be asked to be put onto an advisory board. The thing with advisory boards is that often you might get people who kind of think that by way of just the fact that they are deigning to be on an advisory board, that's it, job done, where you've got my name on your advisory board, what more do you want me to do for the company? And actually you can pay for my name if you want. So what you really want to make sure with your advisory board is actually, what are they going to commit to? What are they going to give you? And actually, what are you going to give them in exchange? So the first thing I would say is that you absolutely need to have some kind of letter of appointment or agreement in place with regard to what your members of the advisory board are going to do for the company. You should probably have some policies in place around what the remit of that board is and how it is going to operate, what you expect it to achieve, and how you are going to measure that outcome in terms of, feedback, plans, strategy, opinions, those sorts of things. People often won't do it for free. So you will need to remunerate them in some way. And that can either be cash remuneration, or quite often, particularly with early stage companies, it might be some kind of equity reward. They won't qualify unless they're employees of the company and meet various other conditions. They won't qualify for what we call EMI options, which are the most sort of tax efficient options that you can sort of give to somebody that we will deal with in cluster 2. But they may well be eligible for non-qualifying options, or indeed warrants over shares. And quite a lot of people are quite happy with that as a form of remuneration. I think the other thing to say with regard to the composition of your advisory board is the same point that we've made in relation to your main board, and that's actually thinking about the composition of it and who's on it and why they're on it, and are they going to actually fulfill the role that you want them to play. I think sometimes there is, both with boards and advisory boards, if you are an early stage company, you can very easily be swayed by this is so and so, look, aren't they amazing? They've grown this company in the US, or they have been part of a FTSE 100, whatever it might be. That is all very well and good, but if they don't actually have the experience of dealing with startups and scale-ups, and actually startups and scale-ups in the UK, and actually sometimes very specifically in Oxford, then they aren't necessarily going to have the skill set that you want them to have or want them to bring to your company or venture. So the other thing is that actually look at what experience they've got, because if it's only in one company and they've only ever done one thing, really, what experience do they have? And so it might be that actually they have an amazing range of contacts and actually they are incredibly well placed. But I would just be careful about ensuring that they can actually bring to you and are willing to bring to you what you want them. I had a great phrase the other day, regurgitated nostalgia, which is the idea that actually, people will just go around talking about how they've done this thing once and how brilliant they are, and therefore they are perfectly placed to be on your board or on your advisory committee. But actually, when you dig underneath the surface, they're just trying to get you to do perhaps what they've done before. And it's, oh, yes, well, when we did this, and oh, yes, when we met with so-and-so, it's like, yes, but actually, how is that going to help my company? And so that is something that, again, just think carefully. These are going to be really pivotal people. And actually also, whilst your organisation is quite small, it's very difficult to hide people. If you've got an organisation of 1,000 people, sort of 2 or 3 people who are quite controversial, kind of get lost in that 1,000 people. Whereas actually, if you've only got 20 people in your organisation, then they can become quite disruptive if they're not aligned what you want to do. Challenge, yes, but challenge respectfully and constructively.
I think that's really good advice, Nicola, because it sort of links also to how you find these directors to build into your board, whether it's the main board of the company or it's an advisory board. And I think the best way is still ask for people's recommendations, people within your sector, people who talk to people at conferences, now that we can get to live conferences again and so on, because personal recommendation is far better than just somebody sending a CV. And certainly Nicola and I have spent quite a lot of our careers rescuing companies from messes where the wrong people have come into boards, to be honest, and which have been very distracting for the companies concerned, and also potentially very destructive and costing quite a lot of money in some circumstances as well.
Building on that, I think the other thing that is worth bearing in mind is that these boards will change and actually probably should change as your company grows. So the board that has the skill set to get your company from seed to Series B might be very different from the board that gets you from Series B to exit. And I'm not necessarily, it speaks, oh gosh, we're at Series B, we need to change people. I'm not saying that at all. And it's not that you will change the whole board. I'm going to pick on the finance director again, but kind of the finance director, or the types of skills that you need to have, for example, to take a company to IPO, so to list on a stock exchange, are very, very different from the skill set that you need when you've got 5 employees and actually you're still in a research phase, and R&D and that kind of thing is so still pretty core to what you do in optimizing your tax reliefs. Boards are a moving thing. Yes, you absolutely get CEOs who have been there from seed through to exit, particularly with the speed of exits that we have seen in recent years, albeit with the markets as they are, people are expecting that to slow down. It's about recognizing that actually as the company grows, you're going to need to bring in different people with different skill sets, enable you to get to the next step.
And sometimes that might mean that you as the CEO might actually not be the right person. You have to be brave enough to think about the company and to step aside. And I'm just this morning actually been dealing with a situation where exactly that thing has happened. The person who has taken the company from pre-revenue spin out when there were 2 people sat in the back room of somewhere or other, to a company now it's got 50 employees, generating revenue, going into the States. They've just brought in somebody who is a heavy hitter in terms of generating revenue, and particularly in terms of translating what they might do and scalability in the US, which is a key market for the company.
I mean, it's one of the things we see quite frequently is there is a dangerous tendency to bring in your mates on your advisory board. Or so maybe your professor, if you're a spin out, for example, that's not necessarily the way to go. So it's probably worth doing a really sensible conversation about what you actually need and going seeking what you need, rather than rewarding your mates for having been having sat up with you through the late nights as you were putting things together. So it isn't an insignificant decision to bring people onto your advisory board.
Again, another thought process around that. In fact, I was talking to somebody the other day who is working with a number of companies in Oxford now. When you have those different skill sets, it may well mean that you have different sorts of personalities that may not necessarily gel together. What we have seen sometimes is a tension between academic founders and perhaps the people who have been brought in as the CEO or the COO or whatever it might be. They just come from very different backgrounds and very different mindsets to things. It doesn't mean to say that this is a disaster, far from it. And actually, there are companies out there who can specialise in working with boards or working with, sort of selected people from boards around sort of coaching them and actually enabling them to see how the other people might view their behaviour or their comments or whatever it might be. And also in reverse, actually why something you're saying might be really important to you, but actually might not be a view that is shared around the rest of the table, but then enabling the rest of the table to understand that too. The second cluster of topics is around building a team and how you incentivize them, what happens when things go wrong, that kind of thing. And it might well be that we sort of invite a guest speaker to come in who can talk very pertinently in relation to that, in particular, those sorts of boards where you have both academics and perhaps sort of people from the outside business world being brought together.
We've had one question which I think leads very nicely into where we're going next, and that's actually how you deal with poor performing board members and actually getting rid of them if they don't actually buck their ideas up. And I was just about to say, Sue, so what happens if it goes wrong? So I suspect that those two probably work together.
There are lots of things that could go wrong. Gosh, that sounds very depressing, doesn't it, when you're all sat there waiting to start a very exciting venture. There are ways in which businesses can get into difficulties. And one of those that we do see from time to time is where directors fall out or directors don't behave well. Just alluded to, Nicola and I, sort of fishing people out of some challenging situations. One I've seen recently was a company where the CEO, who'd been CEO for quite a long time, very experienced person within the field, but he was in his 70s and he wanted to sort of step back. Another CEO from outside. And in retrospect, the warning should have been on the wall when this joining CEO put in around his employment a large range of conditions which sort of indicated that he didn't think that the business was actually viable, which was a strange thing to do. And one of those conditions was that he should get a payoff if it didn't go well. So it was all very odd. And then he somehow engineered the company to not do very well. He was very indiscreet about things and gave bad publicity to the company, which then resulted in it nearly falling apart. And unfortunately, the original CEO came back in again and managed to rescue it, but not without some very tortuous and challenging times. How do you deal with a difficult person? I mean, Nicola's best to deal with that particular bit, I think, first, rather than myself. And then I'll come back to some of the other things that can cause problems. Nicola.
So, I mean, the first things first is make sure you've got an agreement in place with them from the outset, because without an agreement, quite frankly, life becomes very difficult. So first of all, make sure that you have an agreement, whether that's a non-exec director appointment letter or like a services agreement, which is something that we call an employment contract for directors. And then you move into the world almost of employment law. In fact, Sue and I used to run a session called Dealing with Errant Directors. There are a number of factors around it. As I say, when we move on to the sort of team cluster, our employment colleagues, etc., will delve much more into the technical side of it. But very largely speaking, there are processes, and this is where a good chairperson comes into their fore, unless they're the ones causing the issue, or good NEDs come into the fore, unless they're the ones causing the issue, where there's almost like a grievance process. You can raise the fact that you don't think somebody is performing well, you don't think that they're doing what you are expecting them to do. That's your first course of dialogue. You try and put a plan in place to resolve that issue if you think it can be resolved, and that might be okay. And in the event that it isn't, and in the event that the situation continues, then you either look at, right, well, okay, how can we dismiss this person? Do we have legal grounds on which we can get rid of them somehow, or you end up in a discussion with that person which is like, this isn't working for either of us. You really don't want to be working here anymore if you've got, I don't think you really enjoy coming into the office anymore. You're causing a bit of havoc here, so we don't particularly, think it's constructive for the company. How do we move forward? That's when you start looking at things like director service agreements, what are notice periods, what do compensation packages look like? Quite often these people will also have equity in the company. So you need to think about how you deal with their shareholding, as well as how you deal with removing them from a board. And there are lots of things that you ultimately end up sort of needing to consider. But like I say, it's something we will do a much deeper delve into in the sort of second cluster of events, where we talk about retaining and recruiting and retaining teams, or indeed what you do when it goes wrong.
Picking up on what else can go wrong. I mean, I think there's an issue that at the board level, you could actually end up in deadlock, because you could have 50% of the directors on one side and 50% on the other side. One of the things that's quite good to do when you're setting the company up is to ensure that as far as possible, you can avoid that scenario. So rather than having 4 people on the board, you have 5 people on the board, and or you have a chairman who can cast a casting vote. You also should have a culture where directors don't abstain, because they have a responsibility in votes to actually make a decision to progress the business. The other ways in which things could go wrong, of course, are what happens if the technology actually isn't as good as you thought it was, or you fail your clinical trials. What should you do in that scenario? Sometimes there's another place for the technology. You can pivot to something else. See that many, many times. But you have to ensure that if you're going to be able to do that, you've got sufficient cash to do that, and that you can take your investors with you, because they've invested on one particular basis. They may be slightly grumpy. Suddenly they find they've invested in a company doing X, Y, Z, and it's now doing something totally different. It may not be something that they're so focused on. And the other thing that can go wrong, of course, unfortunately, is very perilous, may not be anything to do with the company or indeed the board, is if you can't raise equity funding in order to continue the business and to continue the research and development perhaps that you're prosecuting. And I say it's not necessarily the board or the company's fault, because very often this is down to what's going on in the overall marketplace outside, whether there are available funds, whether people want to invest in a particular sector. There was a concern a couple of years ago that everybody was investing in COVID-related companies, and therefore anything that wasn't life sciences, anything that wasn't within life sciences focused around COVID or have a sort of COVID spin-off, was really finding it difficult to access funds, as either investors went for the COVID companies, or they were holding back on their investments to support companies they'd already invested in. And how do you deal with that? Well, I think in terms of running out of cash, as a board, you need to always have quite a long sight in terms of where your cash runway is, and at what point you need to be thinking about raising your next series of funding, how you're going to raise the funding, i.e. what story you're going to pitch to the investors. Generally, that needs to be around a milestone. So you sort of need to be working out your funding very carefully, bearing in mind it can take 6 to 9 months plus from starting to fundraise to actually securing those funds. So you sort of need to go, okay, my end point is here. If I walk back 9 months, what should I have achieved at that stage that I can go out and tell the market about, that will make them excited and want to invest in us? You can't sort of be aiming to get to your ultimate milestone at the point at which you run out of cash. You're just not going to be able to raise in those circumstances. If you don't raise the funding and you can see that funding is not going to come in, then as a board of directors, you have to suddenly switch hats. And having been thinking about the company and focused upon the company and the prosecution of the success of the company, you then have to pivot yourself as a director and as a board and start to think about those people whom the company owes money, so the creditors of the company. So that could be your suppliers. It's also your employees. It's also government agencies. So you might owe for VAT, for example, or other taxes. And when I say you need to think about that, you need to work out that you will be able to pay them. Duty is something that comes along, your responsibility for running a limited liability company. And that's something we haven't particularly talked about during these sessions. Your company will be limited in its liability to the resources largely within the company, and Nicola will add in a bit more about that in a moment, I'm sure, that means that you as individual directors, apart from in particular circumstances, will not be liable for any debts that the company incurs. As the flip side of that benefit, if you like, having a limited liability company, the directors have a duty to ensure that they think about and put foremost in their mind when the money's running out, the interests of the creditors, because otherwise those creditors aren't going to get paid. And what do I mean by that, and how do you deal with that? You need to know at any one time exactly who you owe money to. You need to understand who you might owe money to if you stop trading the business. So if the company were to cease. And that means, if you think about your employees, you've got to think about things like once you stop employing them, they need to have notice pay. They will be entitled to redundancy payment. So you need to very much think about all those things that might crystallise the day that you stop, which won't be liabilities if you're carrying on the business. And then you need to sort of think about, okay, at what point will we no longer be able to meet those costs as well? It's quite a balance. And I come back to something Nicola talked about earlier, which is the importance of board minutes. Because if as you're coming towards this position where you might be running out of money, you as a board need to be meeting and you need to be concluding on whether you should continue, whether you shouldn't continue, and if you are continuing the business, what your reasons for doing so might be. It could be that you're very close to securing investment. It could be that you're very close to selling a product or a service or something like that. It's all those sorts of things that you need to factor in, and you need to document that because it's contemporaneous notes, and those will protect you and the company going forward. Those are the key things if the financials aren't looking so good. Nicola, have you got anything to add in relation to that?
Sort of Sue said, by reason of being a director of a limited company, there aren't many circumstances where you have personal exposure in respect of the way in which the company has conducted itself. Yes, if there is fraudulent trading, wrongful trading, those sorts of things, then creditors or indeed, people appointed by creditors will look beyond. It's what we call piercing the corporate veil, where actually you lose the protection of the fact that you are in a limited company or a director of a limited company, and people can look to you for personal compensation with regard to the activities that you have carried out. The other circumstance, for example, is in relation to health and safety. So you might have heard the phrase corporate manslaughter. As a company, you have a series of obligations under the Health and Safety Act. And directors are, again, personally responsible for ensuring that the company complies with the Health and Safety Act. And in the event that it doesn't and somebody gets injured or etc., then again, there can be, in certain circumstances, a reach beyond the corporate veil of a limited company to the personal liability of directors themselves. This is where actually directors and officers insurance comes in. So, for example, if somebody had injured themselves, it was as a result of a breach of the health and safety legislation, and there was a personal claim, sort of brought against you as directors, that's when directors and officers insurance comes in. The other circumstance would be, and again, particularly relevant to companies going out and raising money, is there is a whole load of financial regulation around what you can say in relation to your business and the promises that you can make in respect of your business in order to take money off other people. So you can't just go and say, I have just got the most amazing thing and I've got all these people lined up and look, it's going to be absolutely brilliant. What you've got to do is actually be really careful about what you say, because if you are seen to be what we call making a misrepresentation about the ability of your company or the circumstances of your company, again, there can be a direct recourse to directors who take personal responsibility for statements that go into things like information memorandum that some companies use to raise money. Now, this all does sound like massively doom and gloom. And I appreciate it's like really not, sort of having a company, raising money, building a company, getting teams, finding the right people to go on your boards is a genuinely exciting and dynamic time in the life of the company. I think what we are trying to just kind of reinforce is that actually make sure that you've got the right people in place. Make sure you've got the right people in place around your boardroom table. Make sure you've got the right people in place in the wings, can sort of step in and give you that expert advice or can, give you a steer in a certain direction. many years ago. Again, sort of Sue and I have given this talk quite often about what makes a successful company, what makes a successful board. And I use sporting references, even though I am like the least like sports knowledgeable person going. But I did used to use the example of Andy Murray when he was number one. So you can, that actually, yes, he went out and played tennis and was absolutely amazing. But actually behind the scenes, he had his backhand coach, his forehand coach, his nutritionist, his physio, his whatever else, sort of sports people have behind them. And a board is exactly like that. Yes, you might have a CEO with a vision that wants to go and achieve something, but they're not going to achieve it on their own. What they need is a group of reliable people around them to enable them to go and achieve the impact and the outcome that they want to achieve on behalf of their shareholders, on behalf of themselves and everybody else. So it's about putting that right team together, recognizing that as a CEO, you don't know all of the answers, recognizing that your mate in the law department isn't necessarily, or Google aren't necessarily your friends in this situation, and just surrounding yourselves with the team members that are going to get you to your number one Andy Murray position.
Yeah, I absolutely agree with that. Yeah. And I think we've just been asked questions about, as I referenced when I was talking about the priority of payment of creditors in a liquidation. Well, hopefully you won't get as far as that, as in, liquidation processes when everything really has gone very badly wrong and the company goes into insolvency proceedings. And there are very strict rules as to who gets paid in priority. And I'm not going to go into it in particular detail now, but broadly speaking, anybody who's got security, so like a mortgage or something in relation to the company's assets, would come out first. And then we have employees to certain levels, some the revenue to certain levels, and so on. That is something that if you were getting towards that stage, you would be taking advice from a professional to help you to navigate that, because you cannot be expected to be an expert in that arena as a director of a company. But just to be aware that if you are getting towards that stage, you should not go paying people because they've done well for the company, they've helped the company through some difficult times. That really shouldn't be done. And one thing I would just say there is that we have occasionally seen it where, although employees get better treatment, more advanced treatment than other creditors, but outsourced consultants do not. They rank with any other supplier. And we've seen companies trying to pay them at the same rate, same level of priority as employees. And unfortunately, one shouldn't do that. And I think there was a secondary part to the question.
So when they should be informed.
When they should be informed, and do all of them need to be kept informed? If, again, I would say, if you are getting towards a position whereby you think you may not be able to pay all the creditors, that's when you should take advice. But that is generally also the point at which you should consider advising creditors, so that they're in full knowledge if they're suppliers and they continue to supply you. But you need to be really careful around that, because you can bring a whole house of cards tumbling down when you actually didn't need to do that, because people panic in those situations. So I think we come back to take advice and board minutes, which seems to be the flavour of today's session.
And actually, cash flow is the one thing that whenever I'm on a board is desperately important to have on the table every single time.
Yeah.
It's like getting in the car and trying to drive somewhere with no fuel in the tank. If you've not got any cash and enough cash to pay everything that you've got lined up that you might possibly have to pay. So if you know that you've got to drive to Birmingham and you have to get back, you would make sure that you had fuel in the tank to take you to Birmingham and back. And it's the same with finances. I look at it in a slightly more desperately panicky way, because many of you know I go up in a plane. If you go up in a plane without sufficient fuel, that tends to end badly. It concentrates the mind. Think of business as a plane, perhaps, rather than a car, and make sure that you've got the funds in the bank to cover everything you need to do, and a bit more, just in case. Now, running a company is a load of fun at every single level. But it is hard work, and it is a task that you cannot do on a casual basis. You have to read things in advance, you have to get advice, you have to prepare, and you have to keep notes. So that would be the advice. So final chance to ask any questions. Last word of wisdom from Sue.
Oh, good. Well, it is fun, despite what we said. And if you don't believe us, you think we're just saying platitudes here, both Nicola and I are partners in our respective businesses, so run businesses, and we wouldn't be doing that if we didn't think it was fun and we didn't get something.
Yeah, absolutely. And I think I would just say, looking forward to the next session. And so next session in a couple of weeks' time, where we're going to be looking at things like valuation and funding and shareholders agreement and articles of association, all of that good stuff. So, and then after that, I hope that you're all registered for our in-person workshop, because we've now got Ox Sciences and Oxford Technology Investment Fund, Park Walk, Triple Point, all sending investment principles along, together with sort of various CEOs from the ecosystem. So Banjo from Spectrum Diagnostics, Mike from Oxford Endovascular, Danuta from Nucleome Therapeutics, all sort of coming along to sort of share their views, as well as some experienced directors in relation to how they would address the scenarios that we're hoping to put to you in the workshops, followed by beer at tap.
Ooh, final question. Remuneration for advisory board. Would you seek to do that at a normal level compared to an employment contract?
It's almost like a consulting rate, and it will be how many days that you're expecting them to do, and you negotiate with depending on what value you think they are going to bring. But treat them more as sort of non-exec directors rather than being full-time employees.
I think there was an earlier question actually from Himanshu, which is about are video recorded board minutes a thing?
I can't say I've had a huge amount of experience with video recorded board minutes at all. I guess what you could do possibly is record board meetings and then use software to make that into a transcript. But it's not something that I've seen, and board minutes tend to be a refined version. It's a summary of what went on in that meeting rather than, a verbatim of everything. So, and also follow a particular structure. It's not something that I can say that I've come across with any degree of frequency. Being held in this way, yes, but recorded in this way, no.
The board minutes that I produce tend to take up one side of paper for several hours of debate, because all you want is the final situation and not the bloodletting. I mean, the discussion in between times. So. Okay, right. Well, thank you, everybody. We look forward to seeing you in 2 weeks' time. And please do make sure you've also got the date for our 4th session, which involves beer and lots of really fabulous people for the rest of it. Thanks, everybody. And thank you, Nicola. Thank you, Sue.